Although the abortion industry had publicized abortions as being safe and effective to the public, the abortionists who actually performed the in-utero abortion procedures such as the dilation and evacuation method, knew that such an unnatural method was inherently risky and hence, the abortionists searched for better methods of abortion in order to minimize the possibility of lawsuits that could result from injuring the mother. In the in-utero dilation and evacuation abortion method, the unborn baby is literally torn apart, piece by piece. However, some, but not all, abortionists thought that if the unborn baby could first be partially delivered intact through the birth canal, then it would be easier to kill the baby and it would also minimize the possibility of lawsuits that could result from injuring the mother when compared to the riskier in-utero dilation and evacuation abortion method, where the woman's uterus could be perforated by the forceps or by fragments of bone as the fetus disintegrates. This method was labeled intact dilation and evacuation by the American College of Obstetricians and Gynecologists, since the baby's body was kept intact, that is, it was not necessary to tear the baby's body apart as in the in-utero dilation and evacuation abortion method. This abortion method is commonly referred to in the public and by politicians as partial birth abortion. However, many other medical specialists and prominent medical organizations were of the opinion that this intact dilation and evacuation procedure had no medical value and had its own set of procedural health risks, such as causing amniotic fluid embolism, placental abruption, cervical incompetence and subsequent pregnancies caused by 3 days of forceful dilation of the cervix, uterine rupture caused by rotating the fetus in the womb, infection causing sterility, the possibility of a ruptured uterus that could cause the mother to bleed to death in 10 minutes, and many others. Let us look at the mechanics of this procedure. Guided by ultrasound, the abortionist grabs the baby's leg with forceps. The baby's leg is pulled out into the birth canal. The abortionist delivers the baby's entire body, except for the head. The abortionist jams scissors into the baby's skull. The scissors are then opened to enlarge the hole. The scissors are removed and a suction catheter is inserted. The child's brains are sucked out, causing the skull to collapse. The dead baby is then removed. Partial birth abortion is a relatively new procedure. It was largely unknown prior to the discovery in 1992 of an instruction paper on how to perform it, written by abortionist Martin Haskell of Ohio. The outcry over the gruesome details of Haskell's method led to a series of highly publicized congressional hearings investigating the procedure. One witness, Brenda Pratt Schaefer, was a nurse who assisted at an abortion clinic and witnessed a partial birth abortion firsthand. Her description of the process was electrifying. She testified that the instant she saw the baby's body go limp from the procedure, she switched from being pro-choice to pro-life. She walked out of the clinic that day and never returned. In 1995 and 1997, Congress passed legislation to ban partial birth abortion, but President Bill Clinton vetoed the bills. Although the previous federal partial birth abortion bills failed to become law, several state legislatures did enact bans on the procedure while some states did not. In 1997, Barack Obama, as an Illinois state senator, voted against SB 230, a bill that would have prohibited partial birth abortion. What follows is the full text of SB 230. Politicians such as Barack Obama do not consider such a procedure as infanticide, since by his own admission, he does not know when life begins. One of those states that did pass a ban against partial birth abortion was Nebraska. The Nebraska partial birth abortion law ultimately made its way to the United States Supreme Court. On June 28, 2000, in Stenberg v. Carhart, the United States Supreme Court struck down a Nebraska law banning partial birth abortion.
Nebraska is a very conservative, pro-life state. We don't have money, but we do have people, and we have what we feel is the truth on our side.
You know, I've never ever done an abortion on a woman who is happy about having to make that decision. That hasn't happened.
The whole intent of the legislature, I think, was clear. I mean, they're talking partial birth abortions. That's what they wanted to prohibit.
On June 28, 2000, in Stenberg v. Carhart, the United States Supreme Court struck down a Nebraska law banning partial birth abortion. It is a matter of public record that this grisly abortion procedure is extremely painful to the child, is never medically necessary to preserve the life or health of the mother, and indeed is dangerous to women who undergo it. In the words of the American Medical Association, partial birth abortion is not medically indicated in any situation and is not good medicine. So why would anyone want to perform such a procedure? Abortion on demand activists claim the following.
If they're able to remove the fetus intact, they did it because it was the safest procedure for the woman. They don't do it just to do it. These are surgeons who are devoted to increasing the safety of abortion procedures.
That is, abortion on demand activists claim partial birth abortions are on many occasions safer for the health of the mother than the inherently dangerous in-utero abortions. The fact that a live unborn baby is cruelly murdered is of no concern or consequence to them. Notwithstanding the compelling record against partial birth abortion, the Carhart Court held that the abortion right created in Roe v. Wade encompassed the right to partial birth abortion. That is, what was described in Roe v. Wade as a right to abort unborn children had been extended by the Carhart Court to include the brutal killing of partially born children just inches from birth. The Carhart Court based its bizarre conclusion on claims by abortionists that partially delivering an infant before killing it is safer for the mother because it requires less instrumentation in the birth canal and reduces the risk of complications from retained fetal body parts. These same claims would support an abortionist's argument that fully delivering an infant before killing it is safer for the mother and is, therefore, constitutionally protected. The Carhart Court thus thwarted Nebraska's efforts, and the efforts of numerous other states, to, in the words of Justice Thomas in dissent, prohibit a procedure that approaches infanticide, and thereby dehumanizes the fetus and trivializes human life. The result of the court's decision, as Justice Scalia noted in dissent, is to give live birth abortion free rein, and to endorse the absurd notion that the Constitution of the United States, designed, among other things, to establish justice, ensure domestic tranquility and secure the blessings of liberty to ourselves and our posterity, prohibits the states from simply banning this visibly brutal means of eliminating our half-born posterity. The Carhart Court considered the location of an infant's body at the moment of death during a partial birth abortion, delivered partly outside the body of the mother, to be of no legal significance in ruling on the constitutionality of the Nebraska law. Indeed, two members of the majority, Justices Stevens and Ginsburg, went so far as to say that it was irrational for the Nebraska legislature to take the location of the infant at the point of death into account. Instead, implicit in the Carhart decision was the pernicious notion that a partially born infant's entitlement to the protections of the law is dependent upon whether or not the partially born child's mother wants him or her. Following Stenberg v. Carhart, on July 26, 2000, the United States Court of Appeals for the Third Circuit made that point explicit in Planned Parenthood of Central New Jersey v. Farmer, in the course of striking down New Jersey's partial birth abortion ban. According to the Third Circuit, under Roe and Carhart, it is nonsensical and based on semantic machinations and irrational line drawing for a legislature to conclude that an infant's location in relation to his or her mother's body has any relevance in determining whether that infant may be killed. Instead, The former court repudiated New Jersey's classification of the prohibited procedure as being a partial birth, and concluded that a child's status under the law, regardless of his or her location, is dependent upon whether the mother intends to abort the child or to give birth. The former court stated that, in contrast to an infant whose mother intends to give birth, an infant who is killed during a partial birth abortion is not entitled to the protections of the law because a woman seeking an abortion is plainly not seeking to give birth. The logical implications of Stenberg and Farmer are both obvious and disturbing. If the right to abortion entails the right to kill without regard to whether the child remains in the mother's womb, and a child's entitlement to the protections of the law depends upon whether or not the child's mother intends to abort the child or give birth, it follows that infants who are marked for abortion but somehow survive and are born alive have no legal rights under the law, no right to receive medical care, to be sustained in life, or receive any care at all, and if a child who survives an abortion and is born alive would have no claim to the protections of the law, there would, then, be no basis upon which the government may prohibit an abortionist from completely delivering an infant before killing it or allowing it to die. The right to abortion, under this logic, means nothing less than the right to a dead baby, no matter where the killing takes place. Moreover, if, under Carhart and Farmer, a child who survives an abortion and is born alive is not entitled to the protections of the law simply because the child's mother did not intend to give birth, then there is no basis upon which the government may prohibit an abortionist from completely delivering an infant before killing it or allowing it to die. Under the logic of these decisions, if a woman decides to abort her unborn child, and the abortionist decides that the health risks to the woman are reduced by as not stabbing the child in the back of the skull in order to kill the child before completing delivery, the risk reduction occurring because surgical instruments would not be inserted into the birth canal, and the risk of fetal part retention would be reduced, the abortionist may simply completely deliver the child before killing him or her. The right to abortion created in Roe thus appeared to encompass, at least in the Supreme Court's view, the right to infanticide. The viability doctrine in the Supreme Court's decisions in Planned Parenthood versus Casey and Carhart has also created confusion regarding the legal status of premature infants who survive abortions but have little or no chance of sustained survival. In Casey, the court reaffirmed the right of a woman to abort her unborn child, and adhered to the notion that the government's interest in protecting the unborn child is related to viability, or the child's capacity for sustained survival independent of the mother, with or without medical assistance. The Carhart court also relied upon the viability doctrine in striking down Nebraska's partial birth abortion ban.
Good afternoon. I'm pleased that all of you have joined us as the Partial Birth Abortion Ban Act of 2003 becomes the law of the land. For years, a terrible form of violence has been directed against children who are inches from birth, while the law looked the other way. Today, at last, the American people and our government have confronted the violence and come to the defense of the innocent child. Many of you have worked long and hard to see this bill come to fruition, and we thank you for your efforts.
Thank you, Mr. President.
I see some members of my cabinet have come. I appreciate the good work of the Attorney General, John Ashcroft. Department of Health and Human Services, Tommy Thompson. There are a lot of members of the Senate and House here today. I want to thank you all for passing this important legislation. Primary Senate sponsors with us, Senator Rick Santorum. Senator Mike DeWine helped us well in the Senate. Thank you. Steve Schubach was the primary House sponsor, and Steve is with us. Thanks for coming, Steve. I'm thankful that our Speaker is with us today, Mr. Speaker. Appreciate your time. Leader Tom DeLay as well. Thank you for coming. I mentioned three other members of the House. Henry Hyde is with us today, Mr. Chairman. We appreciate your time. Jim Oberstar is with us. Jim, thank you for being with us. Lawrence Plutock from Michigan is with us as well. Thanks for coming. Appreciate His Eminence Cardinal Egan is with us today. Thank you very much. In passing this legislation, members of the House and Senate made a studied decision based upon compelling evidence. The best case against partial birth abortion is a simple description of what happens and to whom it happens. It involves the partial delivery of a live boy or girl and a sudden, violent end of that life. Our nation owes its children a different and better welcome. The bill I'm about to sign, protecting innocent new life from this practice, reflects the compassion and humanity of America. In the course of the congressional debate, the facts became clear. Each year, thousands of partial birth abortions are committed. As Dr. C. Everett Koop, the pediatrician and former Surgeon General, has pointed out, the majority of partial birth abortions are not required by medical emergency. As Congress has found, the practice is widely regarded within the medical profession as unnecessary, not only cruel to the child, but harmful to the mother, and a violation of medical ethics. The facts about partial birth abortion are troubling and tragic, and no lawyer's brief can make them seem otherwise. By acting practice, the elected branches of our government have affirmed a basic standard of humanity, the duty of the strong to protect the weak. The wide agreement amongst men and women on this issue, regardless of political party, shows that bitterness in political debate can be overcome by compassion and the power of conscience. And the executive branch will vigorously defend this law against any who would try to overturn it in the courts. America stands for liberty, for the pursuit of happiness, and for the unalienable right of life. And the most basic duty of government is to defend the life of the innocent. Every person, however frail or vulnerable, has a place and a purpose in this world. Every person has a special dignity. This right to life cannot be granted or denied by government, because it does not come from government. It comes from the Creator of life. In the debate about the rights of the unborn, we are asked to broaden the circle of our moral concern. We're asked to live out our calling as Americans. We're asked to honor our own standards, announced on the day of our founding in the Declaration of Independence. We're asked by our convictions and tradition and compassion to build a culture of life and make this a more just and welcoming society. And today, we welcome vulnerable children into the care and protection of Americans. The late Pennsylvania Governor Robert Casey once said that when we look to the unborn child, real issue is not when life begins, but when love begins. This is the generous and merciful spirit of our country at its best. This spirit is reflected in the Partial Birth Abortion Ban Act of 2003, which I'm now honored to sign into law. God bless.